Be ready. Start. Communication of the award is required to be done if he is not present at the time of the making of the award or none represented them. Service of notice of award is made mandatory. Therefore, this court held that the date of the award cannot be determined solely by reference to the time when the award is signed by the collector or delivered by him in his office. It must involve the consideration of the question as to when it was known to the party concerned, either actually or constructively. The date of the award should be construed in that perspective. The knowledge of the party affected by the decision of the collector, either actual or constructive, is an essential element which must be satisfied before the decision can be brought into force. The communication of the award to the party concerned actually or constructively is therefore necessary. If the award is pronounced in the presence of the party whose rights are affected by it, can be said to be made when pronounced. If the date for the pronouncement of the award is communicated to the party and it is accordingly pronounced on the date previously announced, the award is said to be communicated to the said party even if the said party is not actually present on the date of its pronouncement. If the party is represented, the party is presumed to have the knowledge of the date. In other cases, the communication to the party is necessary. Knowledge of the party affected by the award, either actual or constructive, is essential to satisfy the requirements of fairness and principles of natural justice. The legal position enunciated in Harish Chandra's case being the law under Article 141 and the legislature being presumptively aware of this legal position has altered the law by enacting Section 28A by the Amendment Act. The state, having regard to the directive principles of state policy in Part 4th of the Constitution, which has to undertake diverse measures in a massive scale to promote public welfare and to accelerate economic development, has to inevitably acquire land needed for public purposes, industrial development, housing, educational institutions, etc. Cases of land acquisition of land have become far more numerous than ever before. Exercising the power of eminent domain, when the state takes recourse to acquisition of lands of the individuals or institutions for public purpose to balance the right of the individual whose land is acquired for promotion of the public purpose. It is not in dispute that the trial court, on appreciation of evidence and accepting the prosecution witnesses, convicted the respondents for an offence under Section 304A. Whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Section 304A was inserted in the Penal Code by the Indian Penal Code Amendment Act 27 of 1870 to cover those cases wherein a person cause the death of another by such acts as are rash or negligent, but there is no intention to cause death and no knowledge that the act will cause death. The case should not be covered by sections 299 and 300 only, then it will come under this section. The section provides punishment of either description for a term which may extend to 2 years or fine or both in case of homicide by rash or negligent act. To bring a case of homicide under section 304A IPC, the following conditions must exist, namely, there must be death of the person in question, the accused must have caused such death, and that such act of the accused was rash or negligent, and that it did not amount to culpable homicide. Even a decade ago, considering the galloping trend in road accidents in India and its devastating consequences, this court in Dalbir Singh versus State of Haryana 2005 SCC 82 held that while considering the quantum of sentence to be imposed for the offence of causing death by rash or negligent driving of automobiles, one of the prime consideration should be deterrence. A professional driver should not take a chance thinking that even if he is convicted, he would be dealt with leniently by the court. The principles laid down in that decision are very relevant. When automobiles have become death traps, any leniency shown to drivers who are found guilty of rash driving would be at the risk of further escalation of road accidents. All those who are manning the string of automobiles, particularly professional drivers, must be kept under constant reminders of their duty to adopt utmost care and also of the consequences befalling them in cases of dereliction. One of the most effective ways of keeping such drivers under mental vigil is to maintain a deterrent element in the sentencing sphere.